Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Today's topic is about the two limitations of a will. But before we dive into this topic, if you have any questions pertaining to estate planning or probate and want to schedule a strategy session over the phone for free with me, you can contact me at njestateattorney.com, or above or below is a direct link to my calendar where you could schedule a day and time that works for you. So the two limitations of a will. Now, every time an estate planning client comes in or a potential client comes in, we talk about all the foundational estate plan documents, and one of those being a will. And we always talk about what a will does and sometimes what the limits of a will could be, or like how far can a will take you. And I'm still going to stress wills are important. But in today's video, we're just going to use a hypothetical of your accounts, everything's going to go into your will. So what are the two limits of a will? The first limitation of a will is if you have a will, it needs to be probated. So what is probate? Probate is, in the easiest terms, it's the transfer of property from the deceased individual to a living individual. That's basically what it is without getting into the weeds on it. So if you have a will and you pass away, you are going to have to go through probate. Now, in the state of New Jersey, probate is relatively inexpensive. However, you may need an attorney if the court tells you you do. If there is a will, sometimes it could be just simple and you may not need an attorney at all. But definitely consult with an attorney before you just jump into probate by yourself, because there could be some issues along the way. So then now you're incurring the attorney's fee. So it still could cost several $1,000s. So that's limit one. Limit two, or limitation number two, is that you can only give a direct beneficiary. So in essence, if my estate is valued at let's just say $1 million, and I want to give my friend Michael $200,000 and my friend Joe $250,000 or $300,000, it can only go to those two individuals directly like that. However, if I have a child that is under the age of 18, they cannot inherit. So basically, this would be held in the estate account until, the child reaches 18, and then they're going to get a lump sum check of the other $500,000. But that's something we kind of I would want to avoid. So that's a limit as well, is it can only be a direct beneficiary. So ways to get around this with accounts designating or directing a beneficiary, so a transferable on death or a payable on death, is one way to avoid the probate, and it may be one of the better ways to avoid probate. The second way to avoid these limitations is to create a revocable living trust, where now you can kind of change the beneficiaries around, and people get protected. So those are the two limitations of a will. I hope you found this video informative. If you did, please hit the like button. If you know somebody who may be contemplating estate planning and may have some questions, share this video with them. Tell them you were thinking about them. If you would like to, if you have a question pertaining to this topic or any other topic in estate planning or probate, and you want to schedule a strategy session for free over the phone with me, you can contact me at njestateattorney.com, or above or below is a direct link to my schedule where you could pick a day and time that works best for you. As always, my name is David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.